Good morning. Let's continue to Title 8, Corporate Books and Records, and this is a relatively short title as it is only covered by two sections, 73 and 74. Now, for section 73, I will not read it out loud because it's actually self-explanatory. I'll just point out some provisions like how the book should be kept carefully and preserved at the principal office, and this is why it's important to state in your articles where the principal office of the corporation will be so that the stockholders will know where to request for an inspection of the books. Now, when you talk about here letter B, when you see the word beneficial ownership, this is actually covered by another SEC memorandum circular where corporations are required to report beneficial ownership of shares. Now, what do I mean by beneficial ownership? Hold on, let me just pull that up. When you talk about beneficial ownership, there's actually a very long list as to what it constitutes. But ultimately, beneficial owner is a natural person, not a corporation. So a natural person who ultimately owns or controls the corporation or exercises ultimate effective control over it. What does it mean? Usually, some corporations, as we all know, are owned by one person. As an example, the Gokongwei Group is most likely I'm not saying that this is true, but most likely it's beneficially owned by John Gokongwei. So when you talk about beneficial ownership, you have to go beyond what is just seen. So when you say that a corporation A is owned 50% by corporation B, you have to know, is corporation B effectively controlled by one person? Aside from that definition, the SEC memorandum circular defines it into several categories. I will not go through them anymore because I don't think it's needed. But I just want to point out that there's a percentage given in determining whether a natural person owns beneficial ownership over the shares. And that is when they have at least 25% of the voting rights, voting shares, or capital of the reporting corporation. So in a case where there is a corporation named Corporation A, it will have to report to the SEC if 25% of its voting shares is owned by a particular person. Okay. Now, for failure to report beneficial ownership, the SEC memorandum circular also gives administrative penalties to the corporation, to the director, trustee, and officer who are responsible for failing to report. This is on top of any penalties under the corporation code. Now, note that here under letter G, upon the demand of any director, trustee, or stockholder or member, the time when any director, trustee, stockholder, or member entered or left must be noted in the minutes. So, it's a little bit tedious if there are a lot of stockholders because this should be done only upon demand. It's not all the time. And on a similar demand, the yeas and nays, meaning the approvals and disapprovals towards a certain motion proposed during the meeting. The protest of any director, trustee, stockholder, or member on any action must be recorded in full upon their demand. So these three things I just stated are only written down if there is a demand to do so. So the right to inspection is also seen in this paragraph flashed before you. And the addition or the revision to this provision is that now, under the revised corporation code, a representative may inspect on behalf of a director, trustee, stockholder, or member at any reasonable hour on a business day. This is important for you future CPAs because most of the time stockholders do not know how to determine the true financial position of a company. Now, in any case, the inspection or the reproduction of any item or in the book is bound by the confidentiality rules and also bound by trade secrets. There may be a time where the right can be denied, and this is to a requesting party who is not a stockholder on record or is a competitor of the corporation. So, although the corporation code normally gives penalties to the corporation and its trustees, members, stockholders, board members, no? This provision right here, yan, talks about the penalty against a stockholder who abuses his or her rights to inspect. So in this paragraph here, it talks about the penalties for officers and agents who refuse to allow inspection under Section 161. If the refusal is made pursuant to a resolution, then the liability shall be imposed on all the directors or trustees who voted for the refusal. So the general rule is that the corporation must allow a stockholder's right to demand. If the board determines that the reason for the request to inspect is for improper purposes, which I will discuss shortly, then it is a defense. So it cannot be that refusal would be the general rule. It is actually a defense or a justifying circumstance for the officer. So they are generally liable for refusal except if they are able to prove a good reason for such refusal. If the corporation denies the act, the agreed party may report it to the commission within 5 days from receipt of the report, meaning the report refusing inspection. And in that case, the commission can actually conduct a summary hearing. So this next paragraph talks about the stock and transfer book, and it discusses what must be stated therein. I will not anymore enumerate what these are. How about the last paragraph? The last paragraph talks about a stock transfer agent because it's actually a business, and it's allowed. Yeah, and subject to certain requirements as to when an entity can be considered a stock transfer agent. This is because for most corporations, it would be tedious for the corporate secretary to enter each and every movement in the stocks, especially for corporations with numerous stockholders and stocks. Yan. Alright, so to summarize, what must be maintained in the principal office are the books of minutes of the stockholders or members meeting, the books of minutes of board meetings, the record or book of all business transactions, the stock and transfer book, the record of resolutions, and the record of SEC filed reports. Note that when we talk about the minutes, the signatures of the directors is not necessary, as a mere certification to corporate secretary is sufficient. Okay. What if the stock and transfer book is lost? A new stock and transfer book may be made as long as there are secondary or other evidence introduced to reconstitute its contents. So what happens is that the new stock and transfer book is presented to the SEC for registration with a sworn statement as to how it was lost. When you say that there secondary or intrinsic evidence may be introduced, usually you present that to the SEC to prove that what you are writing down in the new stock and transfer book is actually the same as what was in the lost stock and transfer book. Now, the bylaws can actually restrict the right of inspection in as long as it is reasonable. What do I mean by that? It can say that the right to inspection can be on particular times of the day. But this restriction cannot be made to the extent that, say, in a Supreme Court case, the notice of inspection can only be between the 15th to the 25th of January. So that is unreasonable because out of 365 days, you can only inspect it within those 11 days. So the SEC already clarified that when you talk about the right to inspect, it covers all books, including journals, ledgers, financial statements, ITRs, vouchers, receipts, contracts, and all papers pertaining to the operation of the corporation. And this is why it is a good revision to now allow representatives of the stockholders to inspect. Excuse me. So why is there a right of inspection given to stockholders or members? It is to know how, for stockholders, no, it is to know how their investment is being used or to determine the actual condition of the company. It cannot be made, meaning one of the unjustified reasons or one of the reasons why refusal to the right is allowed is if the inspection is made merely to gratify one's curiosity. Wala lang, you just wanna look. So the board can refuse it. Why? Because it's difficult. Syempre, if someone inspects it, then the corporation will have to take time and manpower to collate all the things you need to look at. Also, there needs to be someone, this is practical, to ask someone, syempre, to watch over the stockholder, just to make sure that the integrity of the records are intact. No alterations are made or nothing is stolen. So the Supreme Court ruled in one case that a stockholder who wants to avail of his right to inspect must set forth in his request for inspection the reasons. So what are improper purposes aside from just gratifying curiosity? Learning business secrets to aid a competitor is one. Another one is to secure prospects for personal business. So that's in cases where a stockholder plans to put up a corporation in direct competition with the corporation. To look for defects in corporate transactions for blackmail or extortion purposes, to pursue one's social or political goals, or to publish or embarrass the company business. Although there is a right of inspection, what cannot be demanded is to take the corporate books out of the principal office for purposes of inspecting them. So you'll ask, Miss, how can they reproduce if there are a lot? There's actually a Supreme Court case I read where the inspecting stockholder actually brought photocopy machines just in case they weren't lent photocopying machines by the corporation. So what's not covered by the right to inspect? As I said, secret formula or processes. Take note that if you read through the provisions, that the penalties provided therein against the directors and trustees are section 161. What can be the remedy if a stockholder is refused the right to inspection? That is mandamus. It's a particular type of case before the court, and damages, or file a case for violation of the revised corporation code under section 161, and also section 73. Section 171. So the sanction that you will see under section 73 applies only to directors or officers who are acting on behalf of the corporation in refusing to deliver the stock and transfer book. This does not apply to third persons or to officers who are not acting on behalf of a corporation. So what's an example of a third person? Say, security guard or a secretary who does not allow you to enter the premises, di ba? They're not covered by section 73. Okay, section 74, the right to financial statements. So there is the 10-day requirement for the corporation there is a 10-day period for the corporation to furnish a stockholder or member requesting for the most recent financial statements. If you look at the last paragraph on your upper right screen, it says here that a certification under oath by the treasurer or president is required if the total assets or liabilities of the corporation are less than 600,000 pesos or any amount determined by the Department of Finance. So far, at present, it's just 600,000. If you look at it, you'll see it's total assets or total liabilities. It's a bit strange because it's basic accounting. Assets is equal to liabilities plus equity, right? So if the assets are 600,000, if it's less than 600,000, then that's easy. But what about cases where the assets are significant, but the total liabilities are less than 600,000 because the corporation is liquid, or there are a lot of stockholders' equity? Does that mean that a certification is still required, especially for large organizations who don't need liability? The answer is yes, because it's under Section 74. Although if you think about it, it's a little bit strange. So, what else? Under Section 177, correlating this to Section 74, the corporations are, there are certain corporations, no, sorry, all corporations are required to submit certain documents to the SEC, aside from the annual financial statements audited by a certified public accountant, which is you guys in the near future. There's also the certification by the corporation's treasurer or chief financial officer, again for corporations whose total assets or liabilities are less than 600,000, and a general information sheet. For corporations vested with public interest, there's also the director or trustee's compensation report and performance report. So what happens if they fail to submit these things like financial statements? Then under Section 177, the corporation can be declared under delinquent status if the failure to submit happens 3 times consecutively or even intermittently in a span of 5 years. So when a person or a corporation is required to file a report with the SEC, they may redact or conceal confidential information, or they may file a supplemental report prominently labeled confidential, separately from the first step. What else must be required to be submitted? A statement of management's responsibility. And this is prescribed in another law, the Securities Regulation Code. And the statement of management responsibility for you future CPAs will actually be familiar with this. It must be signed by the chairman of the board, the chief executive officer, and the chief finance officer, or persons holding equivalent positions under the bylaws. Okay, what else is important for you future CPAs? Under Section 163, if an independent auditor colludes with a corporation in failing to give a fair and accurate presentation of the financial statements or of the corporation's financial condition. So, okay, that's actually about Title 8. I just want to add that the right to inspection does not cover the inspection of bank accounts, because that is covered by the Secrecy of Bank Deposits Law. Let's see. That's the general rule. And the right of a stockholder to inspect a corporation extends to a subsidiary wholly owned by the corporation. So that's Title 8, and I will see you in Title 9.